Hi, my name is Lydia Pearce and I'm from Broadway House Chambers.
My name's Safaraz and I'm also from Broadway House Chambers.
So today we're going to be looking at the law around stalking inspired by the Netflix smash hit Baby Reindeer. But before diving into that, we just need to note that this is not legal advice. The law is correct at the time of recording, which is the 17th of April 2024, and it's taken from the current edition of Blackstone's. This is limited in scope. It's going to be a broad overview of the stalking and harassment law in England and Wales at the moment. If this is something you require any help with, please do talk to a solicitor about your specific circumstances.
Yeah, well, we hope in the future to produce more content like this, where current culture and debate interacts with criminal law. If you want to see more content like this, please do comment down below and or contact us and let us know. Some potential future videos could look into topics such as can bots influence jury trials,
AI wearables and privacy,
offences involved in the honeypot scandal and how to protect yourself,
new offences under the Tobacco and Vapes Bill,
deep fake sexual images,
and the proposed change to law that convicted paedophiles could lose their parental rights. So, Saf, of those potential headlines, which one would you like to hear about?
Well, to me, AI wearables and privacy.
I really like that one. So I think this is an exciting prospect that's come from an American company launching the Limitless in the last couple of days. This is a $99 wearable transcription device, which will transcript everything that it hears. Now, this does have a consent setting, so it will only transcribe your voice, the owner's voice, and it would not transcribe anyone else's. However, that setting can be turned off by the user. It's about the size of a watch face, so potentially it's easy to hide. Now, the advertising talks about this being used in meetings for note-taking, which sounds great. But Saf, what are some of the possible risks with this device?
Well, I mean, the risk I foresee is, for example, in a court where a juror were to wear one of these devices while sitting in a trial, I think they'd have access to a transcript that other jurors wouldn't have, and if used in the courtroom, I think they'd be committing offence essentially.
Yeah, I can totally see how that would happen. Of course, the potential benefits of a device like this is a victim of, for example, stalking could use it for gathering evidence in a way that's possible safer for them due to it being easy to hide. And at that price point, it's accessible to quite a large range of people. And of course, it's got some positive accessibility applications. So I certainly think you're right. That's an interesting topic that we could dive into another day.
Well, turning to our main story today, Baby Reindeer. Just have to put a warning out there. There are some spoilers. So, what is it? Well, essentially, it's a Netflix drama based on a real life experience of a writer and the star, Richard Gadd. It's his experience of being stalked. It's currently #1 in the UK, and it's been well received, receiving critical acclaim and as well as a positive audience response and engagement. So, yeah.
So I've watched Baby Reindeer. I know that you're yet to watch it. As you said, there are spoilers. So if I just set out the brief kind of synopsis of what happens over the series, we meet Donny, the character played by Mr. Gadd, and he's a struggling comedian working in a pub. Martha, the woman who eventually becomes his stalker, comes in one day and he gives her a cup of tea for free. And from there, their relationship of sorts, or certainly their knowing of each other, develops. It starts off as a slightly intense, maybe a little bit flirty friendship, but it escalates really quickly into stalking type behavior. And what we see from Martha over the course of that behavior, which is over a number of years, is things like 40,000 plus emails, 350 hours worth of voicemails, Facebook comments everywhere, Facebook messages. She's phoning him, she's phoning friends, she's phoning family. And it eventually gets to the point where she's even making threats of violence towards people. So yeah, that's the case. And one of the main points in that drama is the fact that Donny, the complainant, keeps going back to the police over and over again, and he doesn't really get the support that he's looking for. In fact, one of the things that he's told by a desk officer a few times is that unless she's making actual threats, there's nothing much the police can do. Now we're going to dive into that comment made by the fictional officer and answer, is that actually true or not?
Well, I'm now going to highlight some real life statistics, and that's been taken from the Stalking Conference 2023, Protecting Victims and Tackling Perpetrators. The Office for National Statistics, ONS, estimates that 2.5 million people every year experience stalking in England and Wales. The National Police Chiefs Council, NPCC, found stalking crimes rose by 18,000 in the period between 2018 and 2022. And according to the National Stalking Consortium, that just 5% of stalking cases in England and Wales resulted in a charge by the CPS, essentially.
So what actually is the law to protect people from stalking and harassment in England and Wales? Now, as I've said before, the police officer turns Donny away multiple times, saying that unless Martha has threatened him, there's nothing the police can do. So let's have a look at the law and find out whether that's true or not.
Well, let's start by asking, where does the offence of stalking come from? Well, it stems from the legislation Protection from Harassment Act 1997. Although stalking offences only were added in 2012, it comes from Section 2A, offence of stalking. It carries a maximum sentence of 6 months. There's also the higher offence, Section 4A offence, stalking involving fear or violence or serious alarm or distress, and that has a maximum sentence of 10 years.
Now, as you've heard, this law comes from the Protection of Harassment Act. And there are some differences between stalking and harassment, but there's a lot of overlap here. So we're going to look at both. Now, you've got Section 2 harassment, which has a maximum sentence of 6 months summary only. And then there's Section 4 harassment, which is harassment with a fear of violence, with a maximum sentence of 10 years. Now, we're going to refer to these just very broadly as the lower forms of stalking or harassment, and then the higher forms of stalking or harassment. And by that, we're talking about the 6-month offences or the 10-year offences. Now, what you will have heard there, the difference between the two higher forms of the offences is that stalking, the higher form, the 10-year form, can be committed either by involving fear of violence or by serious alarm or distress. Now, the higher form of harassment can only be committed with a fear of violence. So the serious alarm or distress element does not come into that higher form of harassment.
Well, now looking at the offence of the Section 2 harassment, Section 1, subsection 1, a person must not pursue a course of conduct which A, amounts to harassment of another, and B, which he knows or ought to know amounts to harassment of the other. Section 1, again, subsection 2, for the purposes of this section, 2A, 2C, the person whose course of conduct is in question ought to know that it amounts to or involves harassment of another if a reasonable person in possession of the same information would think the course of conduct amounted to or involved harassment of the other. Now, Section 7, subsection 3, a course of conduct must involve, subsection A, conduct on at least 2 occasions in relation to that person. Now, subsection 4 does specify that conduct does include speech.
So thank you, Saf, for going through those elements for us. And let's just deep dive into some of those parts. So what is a course of conduct? So in order to establish a course of conduct, the prosecution would need to show that this is a course of conduct instead of, or rather than, a series of unrelated acts. In fact, that is crucial to the success of any prosecution. The events must be so connected in type and in context as to justify the conclusion that they amount to a course of conduct. Now, this means that the fewer and further apart the incidents that the prosecution rely upon, the less likely it is that they will be regarded as a course of conduct. But circumstances can be conceived where incidents as far apart as a year could constitute a course of conduct. Now, there are some more unusual examples from case law of what could constitute a course of conduct, and that includes 2 letters 4.5 months apart, 3 phone calls over 5 minutes, or 95 phone calls over 90 minutes with threats to keep calling all night. Now, there was even an example of a deliberate failure to control dogs following multiple complaints. Now, what we're much more likely to see in practice is things like ongoing phone calls, ongoing coming to the house. In cases of harassment, usually I find that in neighbour dispute type cases. So you might have things like things being thrown over the fences at each other, bit of shouting at each other when they're going down the garden path. Is that the kind of thing that you found, Saf?
Yeah, yeah. In the magistrates, you come across stuff, just little things like that. And again, it doesn't necessarily amount to stalking, but those things are harassment essentially.
So if we go on, in fact, if you're able to explain further of what actually is harassment.
Yeah. So again, Section 7, subsection 2 references to harassing a person include alarming the person or causing the person distress. Harassment is generally understood to involve improper, oppressive, and unreasonable conduct that is targeted at an individual and calculated to produce the consequences described in Section 7. A course of conduct which is unattractive and unreasonable does not in itself necessarily constitute to harassment. It must be unacceptable and oppressive conduct such that it should sustain criminal liability. And an example of harassment behavior, as Lydia pointed out, again, neighbors, shouting abuse at one another, neighbor disputes, something you normally run into in the magistrates, just a course of conduct, day in, day out, just shouting abuse at one another.
Yeah, so I think what we've covered there, it needs to be on 2 occasions or more for it to be a course of conduct. And of course, the type of behaviour that we're talking about is exactly as you've just outlined there. So we know what the actions are of a potential harasser, but we also need to establish, if we're going to be prosecuting this type of case, the mens rea. Now, this means the mental element of the offence. So this offence isn't just about what the potential harasser has done, it's about what their intent was behind it. Now, that Saf has already read out for us in the definition is that the defendant knows or ought to know that the course of conduct amounts to harassment of the other. And then there's further assistance in section 1.2. The purposes of this section, or section 2A, 2C, which is where we'll go further into stalking, the person whose course of conduct is in question ought to know that it amounts to or involves harassment of another if a reasonable person in possession of the same information would think the course of conduct amounted to or involved harassment of the other. Now, this is an objective test, and no allowance can be made for conditions such as paranoid schizophrenia that may affect the defendant's perception, unless they are so severe as to enable the defendant to raise a defence of insanity. Now, in the television show, certainly Donny is concerned about the mental health of Martha, and it would appear that she doesn't really appreciate the impact of her actions. But what we can see from this part of the law is that if she's not able to understand the impact of her actions, that's not going to provide her a defence. It's whether a reasonable person looking at those actions in the possession of the same information would think that the conduct amounted to or involved harassment of the other.
Well, now turning to harassment with fear of violence, this comes from section 4, putting people in fear of violence. Subsection 1, a person whose course of conduct causes another to fear on at least 2 occasions that violence will be used against him is guilty of an offence if he knows or ought to know that his conduct or his course of conduct will cause the other so to fear on each of those occasions. Section 2, for the purpose of this section, the person whose course of conduct is in question ought to know that it will cause another to fear that violence will be used against him on any occasion if a reasonable person in possession of the same information would think the course of conduct would cause the other so to fear on that occasion. As to the meaning of course of conduct, case law stipulates that there must be at least 2 occasions involving threats or other conduct giving rise to the fear of violence. On the other hand, it would be sufficient for this fear of violence on a separate and later occasions, as where the defendant tells the victim, I'll come back and get you. That's essentially the position. And also, it must be borne in mind, the defendant's conduct must cause the complainant to fear that violence will be used. It's not sufficient for it to frighten the complainant as to what might happen. And that's essentially it.
Thank you. So that's covered the harassment offences. So we've got what we've called the lower form of harassment, and then harassment with fear of violence, which is what you've just gone through there. So I'm just going to move on and talk about the law on stalking. Now, the reason we've talked about the law on stalking after harassment is because actually there are some elements of harassment that you need to prove in order to then prove the stalking. So under section 2A1, a person is guilty of an offence if the person pursues a course of conduct in breach of section 1.1, that's harassment that we've just been talking about, and the course of conduct amounts to stalking. Now, for the purposes of section 1B, so whether the course of conduct amounts to stalking, and section 4A, 1A, so that's going to be the higher stalking offence, a person's course of conduct amounts to stalking of another person if it amounts to harassment of that person, the acts or omissions involved are ones associated with stalking, and the person whose course of conduct it is knows or ought to know that the course of conduct amounts to harassment of the other person. Then section 3 gives us a list of examples of acts or omissions which in particular circumstances are ones associated with stalking. So I'm going to run down those. We've got A, following a person, B, contacting or attempting to contact a person by any means, C, publishing any statement or other material relating or purporting to relate to that person or purporting to originate from a person, D, monitoring the use by a person of the internet, email, or any other form of electronic communication, loitering in any place, whether public or private, interfering with any property in the possession of a person, or watching or spying on the person. Now, the acts or omissions listed there are given as examples, so that is not a finite list. It means that there is the ability for this to grow, for example, to track changes in technology. So newly developed forms of stalking, such as the electronic tracking of an individual, and I've certainly dealt with cases where tracking devices have been hidden on vehicles. Also making repeated allegations against the other person may amount to stalking or form part of a wider campaign of stalking. Now, again, I'll just review over the actions that we know Martha took in Baby Reindeer. We know that she goes to his work a lot, spends a huge amount of time there, that she goes to his gigs. When she's at the gigs, she's harassing him, she's shouting at him, she's heckling him. Some of those heckles and some of the catcalling that happens in other places does become homophobic. She's using, of course, emails, phone calls, voicemails, social media to try and keep in contact with him. She gets his email address from his website, so we know that she's been going on there. She then turns up, she's hanging around outside his house day after day after day. She follows him home from work. So there's a lot of stuff going on there. So Saf, given what we know about Martha, what do you think? Is this harassment or is it stalking?
Well, in my opinion, it's clearly stalking. I mean, the examples listed in subsection 3, again, subsection 3A, following a person. She's clearly following a person. She's following him numerous times. So again, I think stalking's made out in that regard. B, she rings him numerous times. His email, she emails him a lot. By Facebook, Twitter. Again, so contacting or attempting by any means. Again, B's made out. Monitoring. Again, D, she stalks his website to see where he's performing. Again, I think D's made out. And again, loitering outside of his house, waiting outside his house, waiting outside his place of work. Again, E's made out. So from a number of those examples, it seems to be that she's really stalking him.
Yes, I mean, I would definitely agree with that analysis. There are plenty of elements of stalking that we can tick off in the Martha example. Now, also, Saf, do you think that this is more likely to be simple stalking or higher stalking under section 4A? Just at the moment, we haven't gone into the law on 4A, but we know that it's going to involve either a fear of violence or a serious alarm and distress with a serious impact on the person's life.
Well, given the period she's done it over, I think given the length of time, I think you said around 4 years to 4.5 years. I think given the period of time and the amount the amount she's done it, I think it would cause serious alarm and distress. And for me, I think it would go into the higher one, although we haven't gone into it yet. I think it would be covered under Section 4A, just because given the quantity, the sheer volume of times she's attended, she's followed him, she's rang him, she's emailed him. I think for that reason, I'd place it under the higher Section 4A.
Well, let's start looking at that section then. If you're happy to kind of help us through that, and I'll bring it up on the screen.
Well, Section 4A, that deals with stalking with a fear of violence or serious alarm or distress. Now, Section 1 of that, a person A, whose course of conduct amounts to stalking, and either, now there's two, 1 and 2, causes another person B to fear on at least 2 occasions that violence will be used against person B, or causes person B serious alarm or distress, which has a substantial adverse effect on B's usual day-to-day activities, is guilty of an offence if person A knows or ought to know that person A's course of conduct will cause person B so to fear on each of those occasions, or, as the case may be, will cause such alarm or distress. Now, subsection 2, for the purpose of this section, person A ought to know that his or her course of conduct will cause person B to fear that violence will be used against person B on any occasion if a reasonable person in possession of the same information would think the course of conduct would cause person B so to fear on that occasion. Now, subsection 3, for the purposes of this section, person A ought to know that person A's course of conduct will cause person B serious alarm or distress, which has a substantial adverse effect on person B's usual day-to-day activities. If a reasonable person in possession of the same information would think the course of conduct would cause person B such alarm or distress. Now, it's not enough to establish that conditions existed which might reasonably have engendered a fear of violence. The court or the jury must be sure that such a fear was actually engendered.
So going back to Martha, the Martha example again, now near the end of the stalking behaviour from Martha, it does actually culminate in some threats of violence. There are threats to stab. So I can't remember whether it's him or whether it's his family. So we do end up with some level of threats of violence. Now, if those have been on 2 or more occasions, what do you think Martha would be potentially looking at here as far as a charge is concerned?
Well, I think Martha would be looking at essentially causing person B to fear. So it would come under causing person B to fear on at least 2 occasions that violence would be used. So essentially, it would come under the first B1 essentially, and I think it would show a course of conduct from her.
Now, of course, we can come back to the comments made by the fictional police officer that if she's not made threats to you, there's nothing we can do, mate. But if there hadn't been those threats of stabbing, given everything else that Martha has done, do you think that actually 4A stalking could be made out using that B2 definition?
Most definitely. I think the police officer in the show has got it slightly wrong, because B2 does state causes B serious alarm or distress, which has a substantial adverse effect on B's usual day-to-day activities. Now, it's not necessary for there to be any threats. This is just essentially person A's behavior has caused B serious alarm and distress, and because of that serious alarm and distress, it's had an adverse effect on their day-to-day activities. So essentially, by her turning up at his house, waiting outside his house, maybe he's had to use his back door, maybe he's had to go on a different route, maybe her being outside his workplace has caused him to leave later, maybe he's had to change address. So again, all these sorts of things would be covered. Again, she wouldn't have to threaten him, so that would be covered under B2. Again, which just causes serious alarm or distress, which causes you essentially to change your usual day-to-day activities.
Yes, I mean, going back onto the facts of the fictional Martha and Donny case, we know that over the course of 4 years, Donny has to change his address. He's concerned about his walk home. He possibly changes the walk home because she confronts him and follows him at some times. We know that he is getting harassed at his place of work, not only at the pub, but then she's turning up at his gigs. He potentially has to stop doing some gigs because of her presence. We know that he takes some time off of work because of it. And as I've said, he does change his home address. So do we think that that's enough to trigger these serious alarm and distress, which has had a substantial adverse effect on Donny's day-to-day activities?
Well, yes. I mean, I would say moving address, that that is a substantial, in my opinion. Moving address isn't a small thing. You have to, you literally have to move your entire life and go somewhere else. So I think that is quite substantial. And I think possibly that's what, when this was drafted, that was something that was taken into account. The issues surrounding a lot of people who face issues of stalking and harassment to this level. I do believe there is a lot of people who have to move as a consequence of this stuff. So substantial, I believe that is what they probably would have envisaged. So yeah, I do believe it is covered.
Yes, I mean, I've certainly dealt with a stalking offence that was this type of stalking, not the one with the threat of violence. And in that, the complainant, I think, had to move address about 5 times. And the stalker kept on finding her. It was non-stop phone calls, even when she changed the number. It was turning up at the house. It was non-stop, and the impact on her life and her work, it was absolutely devastating. So completely right. No, you don't have to wait for someone to threaten you in order to prove that you're being stalked. Just a bit of history, because we know that the show is based in around the mid to late 2010s. I think it's around 2015 to around 2018-ish. Now, stalking wasn't an offence under this law until 2012. But yeah, by 2015, when the stalking allegedly starts in the show, it is already in law. So that doesn't explain why the officer said what he said. Of course, it is fictional, but we don't know why this officer has said what he said. And I know that Mr. Gadd himself has talked a lot about the concerns he had about the lack of support from the police. Plus, even if it had been prior to 2012, she might have been guilty of the lower form of harassment in any event. So without the threats, of course, that lower form of harassment could have still been made out. So if you're considering going to the police because you're subject to what you think is either stalking or harassment or any abusive or unwanted behaviour, please don't think that you have to wait for there to be threats of violence for you to be able to report that. Just another kind of small technical point here, that if your case were to go to court and the stalker or the harasser was tried for what we are calling the higher offences, it is possible for the jury to find them not guilty of the high offences, but still convict them of the lower offences. So it might be that, even where you're not successful, or prosecution, are not successful on securing an up to 10-year sentence, there's still the option of an up to 6-month sentence. We're going to talk about some other options in sentencing in a moment. But I just think before that, do you want to just touch on defences quickly?
Yeah, so just touching on those quite briefly. Essentially, it would be a defense for the defendant to prove that the offence is not proved by, for example, if there was a course of conduct, if there wasn't a course of conduct or no fear of violence, along those lines. There's also defences set out in Section 1, subsection 3 of the Act, including pursuing a course of conduct for the purpose of preventing and detecting crime. So essentially, what you have police officers doing, when they're attending maybe a suspect's house, or watching a suspect, or essentially stalking a suspect, that's for the purposes of preventing or detecting a crime. Again, hopefully it can be seen why that shouldn't be criminalized, or essentially that it was pursued under any enactment or rule of law to comply with any condition or requirement imposed by any person under any enactment, or that the pursuit of the course of conduct was reasonable. Now, turning now to some other defences in case law, essentially, when I worked as a county court advocate for many years, I dealt with debt recovery matters. Now, debt recovery matters, debt companies are sometimes accused by defendants when they are trying to recover their debt through the small claims in the county court. They're sometimes accused of harassment. However, there's a potential defense that is provided by case law, which essentially says pursuing a debt cannot amount to harassment if that's what the debtor is doing. Now, yeah, those do set out a few defenses in legislation and a defense in case law.
So if we move on to sentencing, what I'm going to suggest we do actually, Saf, is that we just look at sentencing options for the higher form of stalking harassment, stalking, and we go through that together. We'll go through the sentencing guidelines because, again, spoilers, we know from the TV show, the fictional Martha received a sentence of 9 months custody, and she appears to receive that in the Crown Court. It looks like we go in at the plea and trial preparation hearing where she pleads guilty. That would mean that she was due some credit, 25%. But it means also that she must have been, if she's ended up with a sentence of 9 months, that she must have been sentenced for what we've been calling the higher form of harassment. So I'm going to bring up the sentencing guidelines. And if you're happy to just talk us through that. So here we are, we've got the harassment guidelines, the stalking guidelines. So that's interesting that actually they are both, it would be the same sentencing guidelines, whether they're convicted of the higher form of harassment or stalking. And we've got a maximum of 10 years custody. So first of all, the court will be looking at culpability. Now, do you want to go through some of these culpability factors?
Yes, so essentially at culpability A, that's very high culpability. It's when it's an extreme nature, and essentially when one or more of the culpability B factors or the extreme culpability indicated by a combination of both B factors may elevate to category A. So essentially, it's just when the factors in B are so extreme, it has to be taken as a very, it has to be bumped up a bit, essentially. So, for example, the high degree of the persistent action over a prolonged period, it may quite possibly be that 4.5 years can be bumped up into the A, depending on the view the judge takes on the day, or depending on how it's perceived, because it is quite a persistent act and it's quite a prolonged period, and depending on how you view it, it could be seen as an extreme. Now, the high degree of planning or sophisticated offense, essentially, the way she had access to, the way she was emailing him thousands of emails, accessing, messaging him on Facebook, Twitter, accessing his website. Again, meeting up outside his workplace, staying outside of his house at the bus stop. Again, there must have been a high degree of planning for her to know where he works, locate all his social media. And again, it could be that the extremeness of it all combined could possibly bump that up into high culpability. But again, those are some of the things. Again, conduct intended to maximize fear or distress. The threats, those could possibly be seen to intend to maximize fear or distress. Offense motivated by or demonstrated hostility based on following characteristics. Now, you've heard Lydia mention she attended one of his gigs, his comedy gigs, and she was I think shouting homophobic slurs. Again, that could also place it in the higher culpability just by her saying those because it is motivated essentially based on his sexual orientation. So yeah, though that's high culpability. Again, looking at medium culpability, that would be conduct intended to cause some fear or distress. Now, let's say her course of conduct was a lot less, maybe over the span of maybe a few weeks or a few months. That could probably be seen to cause some fear, and then some planning, possibly just her turning outside his house, maybe emailing him a bit, maybe not as much as what she's been doing on this occasion. And again, the scope and duration falls between that of B and D. Now, essentially, that's maybe not something as prolonged and persistent as seen in B, maybe not something given for years or even for a year, maybe something again like a few months.
So if we come into that, so I think what we're saying is that it's definitely high culpability, and it could be pushing up into the A, very high culpability. And certainly they've got that element of, there are some elements of this that appear to be homophobic, although it doesn't appear that the entire offending is motivated by that element. Now, what was quite interesting is the harm level here. Now, in the TV show, we see that it clearly has a significant impact upon Donny for the reasons that we've described before. He is not sleeping. It definitely seems to impact his health. There's some level of psychological harm, it would appear. And we know that he's had to make considerable changes to his lifestyle. Now, what is interesting about the television show and Donny is that he's very clear that he's concerned about Martha's well-being. And when he goes to the police, he's very much more interested in her achieving some level of help than he is more, at the beginning at least, he's more interested in that than essentially punishing her. We don't have what's called a victim impact statement from Donny in the TV show. So we don't know if he provided one or not. If he did, how much did he describe the level of harm it's caused him? And how much has he attempted to put forward the level of sympathy that he has for Martha? It might be something like that that takes us from what could be a category 1 case down to a category 2 case. So if we look at the sentencing guidelines here, we can see if it was extreme at all ends, it would be a starting point of 5 years custody with a range of 3.5 up to 8 years. But I think it's probably slightly closer to culpability B. I think it's got the possibility of being in category 1, which is a starting point of 2.5 years. But given what we know Donny says about his sympathies, and that we know that the writer of the show has also talked about how the high level of sympathy that he had for Martha and the level of help that he wanted her to get, it may well be that this had actually ended up as a 2B offence with a starting point of 36 weeks. Now that's actually 9 months. Category range 12 weeks to 18 months. Now, we know from the fictional TV show that she ended up with a sentence of 9 months duration. So would you be able to just quickly run us through how you think the court might have got to that sentence?
So just briefly, I think looking at her pre-con, she's got a similar pre-con. They would have started with a 9 months. They would have probably added on a couple of months. And then given the fact that she pleaded guilty at the PTPH, reduced it slightly back down to 9 months. And I think that's probably how they've got it.
Yeah, I agree. We also know that in the TV show, Donny got a 5-year restraining order. Now, just before we have to leave, if we run through some of the remedies that you may encounter as a complainant in a case like this, you might be able to get a harassment warning from the police. That's something that would take place before any kind of police arrest or charge or court case, and it may be enough to deter your offender. You could also apply for a restraining order on conviction or acquittal, and that can be for any length of time, including until further order, so essentially indefinitely. If you were to go to court, there are special measures that are available to help you give your evidence as best you can. There are witness services and support charities available, and of course you can approach the police if you are undergoing any type of harassment or stalking or anything that is causing you concern. So, Saf, will you be watching Baby Reindeer?
Yes, I will be. Most definitely.
It's a brilliant watch. Well, thank you very much for joining us today and this very quick tour of stalking law.
Well, thank you.
Thank you. Bye.
Bye.